Good evening, everybody. Thank you so much for coming out tonight. As you know, my name is Matthew V. Ferdon from the Law Office of Matthew V. Ferdon, PLLC. Please feel free to call me Matt. All right. I specialize in estate planning, Medicaid planning, asset protection, right, estate and probate administration, as well as real estate. Tonight's seminar is a workshop where we'll be discussing basic estate planning, right, probate, as well as asset protection planning too. Okay. So those will essentially be the three segments of the seminar tonight. Once we've done those three segments, each one is about 20 minutes. There'll be about 15 or 20 minutes for questions. I'm glad to answer any questions that you might have. Now, a lot of people here, which I love, right? So maybe we don't get to your question, right? Or maybe, right? I have another question that I didn't get to ask Matt. No problem, right? The reason why that's no problem is because you can always give me a call. You can always send me an email, and I never, ever charge for questions, okay? There you go, right? So please feel free to pepper my office with questions. I'm glad to answer any questions that you might have, okay? With that said, right, I have an office right here in Hopog, right? Makes life pretty easy. I'm just right there on Smithtown Bypass, next to Pace's Steakhouse, right? It's 111 Smithtown Bypass. I'm Suite 105, right? So feel free to stop by if you'd like, right? I have candy there too. So again, local estate planning attorney, right? Never charge for questions, nor do I ever charge for your initial consultation, right? So you want to come in, you want to get a little bit more education. That's what this is all about, right? You might have gone to some of these seminars in the past, right? A lot of times they have you sign in, right? They want you to sign your name. They want you to put your email address so they can, blast out emails to you and, pepper you with mailings and stuff like that. That's not why I'm here today, right? I'm just here to provide some education. That's it. Answer any questions about estate planning or probate or asset protection that you might have. That's it. There's no pressure, right? This isn't a sales pitch, right? You get free candy, you get some good information, and life is good. That's it. All right. Go ahead, sir. Really, you just call my office, right? You set up, and the question was, what's involved in an office visit, right? All you have to do is call my office, set up an appointment with me. I have a separate conference room. You come in, right? We generally do about an hour. If it goes over an hour, no problem. I'm not going to kick you out, right? But I'm there to just answer questions that you might have, give you an overview of how estate planning might benefit you, as well as asset protection and anything else that you might have going on legally. All right. I have 10 years of experience, right? I've worked for law firms, big and small. I now have my own law office, which I like the most because no boss, right? The other thing is it's just me, right? Why is that good for you? It means I don't have a lot of overhead, right? That means that I can keep your legal fees a little bit lower than the average attorney, essentially, right? Yet I'm still just as good, still have all that knowledge, still eager to help you in any way that I possibly can, okay? I went to law school right here on Long Island, Hofstra University School of Law, now called the Maurice A. Dean School of Law at Hofstra University. It's quite a mouthful, right? Some of us snarky attorneys call it the Mad Law School, right? Maurice A. Dean, very, very funny, right? A little bit of lawyer humor. You might get a little bit of that. It's not very good, I promise, but you just have to deal with it. I'm sorry. All right. With that said, ready to jump right in to what I call basic estate planning. All right. Now, what is basic estate planning? Basic estate planning basically consists of having 4 documents in place, right? You just took handouts that explain what those 4 documents do. Of course, I'm going to give you a little bit more kind of layman's explanation of it. And of course, if you have any questions about those documents, you can always give me a call. What are those 4 documents? Last will and testament, power of attorney, healthcare proxy, a living will. Right? All 4 of those documents, very important for, I would say, everyone in this room, including myself, right? Including those out there in YouTube land, right? To have in place. A lot of people ask me, Matt, when do I need to have basic estate planning in place? Well, I say if you check off any one of these 3 boxes, and a lot of us will check off more than one box, then you should have these 4 basic estate planning documents in place. What are those 3 boxes? Well, if you get married, really important to have these 4 documents in place. It's not just you anymore. You got a teammate, right? And we help each other, right? We use these documents to help each other if God forbid something happens. We'll, of course, go into that in much more detail in just a few minutes, right? Well, what if you have children, whether you're married or not? Very important to have these documents in place. You'll see why that's so important in just a moment, right? So whether you're married or not, whether you have children or not, if you amass any significant amount of positive net worth, I say a net worth of $50,000 or more, right? And if you have a house, you might already be there, right? Again, married, children or not, very important to have those 4 documents in place. So if you check off all 3 of those boxes, I expect to get a phone call tomorrow. I'm just kidding, all right? My point is very important to have these documents in place. A lot of people wait till the very last minute, and that can create problems, right? What is estate planning? Advanced planning, planning for something that might happen in the future. A lot of people, they wait for a crisis to happen. Uh-oh, I need long-term care. Now I'm going to go see the estate planning attorney, and now we're a little bit handcuffed, right? Our options are limited as far as what we can do. So I always say estate planning, right? It's smart to get done right away, right? If you check off any one of those 3 boxes, we can always update your plan later, right? A few years go by, things change. I had more children. I got divorced and then I got remarried, right? Or I just got divorced, right? I started a new business and it's starting to take off. Now I need a different type of planning, right? More high net worth planning, so on and so forth, right? So as your financial situation changes, as your familial situation changes, it's a good idea to update that basic estate plan. All right. Now let's dive right into those 4 documents. The first document we have is, of course, the last will and testament. A last will and testament is the cornerstone of every basic estate plan, right? But the last will and testament only comes into play after you passed away, right? Doesn't do anything while you're still alive, essentially, right? So what does your last will and testament do? It's a document where you appoint somebody to be in charge of your estate after you passed away. An executor, I think people are pretty familiar with that. They've at least heard the term, right? So we appoint somebody of our choosing. Why is it so important to have a will in place? Because it means that your wishes are the wishes that are going to be carried out, not the state's wishes, not somebody else's wishes, right? It's what you want to happen. So a lot of people, they might pass away without a will, right? At that point, anybody that is one of their heirs can be the administrator of their estate. There's no executor because there's no will, right? Well, it might be someone that we don't want to be the administrator of our estate. It might be the person that doesn't have a good head on their shoulders for finances, right? Or is not super trustworthy, or is not reliable, so on and so forth, right? So that's why having a will, purpose 1, is so important, because we are in control of who administers our estate after we pass away. We also like to appoint successors, right? I appoint my wife. I'll use myself as an example a lot of times, as you'll see. So I appoint my wife as the executor of my estate. What if, God forbid, my wife predeceases me, right? Or my wife absconds to Fiji to become a surfing champion. She's not around anymore, right? Well, now I have to have a successor appointed in order to take up the job that the executor does, all right? What else does a will do? A will basically sets out who the beneficiaries of your estate will be. Again, you determine who the beneficiaries will be. If we pass away without a will, your heirs will go to your estate will be distributed to your heirs, right? But it might not be the heirs that you want to get it, right? What a lot of people don't realize, they think, oh, I don't need a will. Everything's just going to go to my wife when I pass away. That's actually not true, right? If somebody passes away without a will and they're married with children, right? The spouse gets the first $50,000 of the estate and half of whatever's left. Then the children get the other half of whatever's left. That's usually not what we want, right? We want it all to go to our spouse. This way our spouse can benefit from those assets, from that money. And then when our spouse passes away, everything goes to the kids, right? So having that will in place, so important. This way you can be in control of what happens after you pass away. Wills are also important because it allows us to do certain things, right? Depending on, our life situation, essentially, right? So for those who are a little bit younger in the room here, right, you might want to have a guardian set up in your will, right? God forbid me and my wife, right, we perish at the same time, right? Knock on wood, right? If that happens, we have 2 minor children, right? We don't want the state to determine who's going to be their guardians. We want to pick, right? I want it to be my brother and sister, or I want it to be my wife's brother and sister, or maybe it'll be my mom and dad or her mom and dad. It doesn't matter because it's whoever we want, right? It could be my best friend who, specializes in this type of thing, right? So again, it gives you the control to make sure that who you want to be in place is in place, right? What else does it allow us to do? It allows us to set up trusts, testamentary trusts. We're going to talk about trust in a little bit more detail in just a few minutes, but we'll be talking mostly about living trust, trust that you set up during your lifetime, right? So, but a testamentary trust is a trust that's set up through your will, right? So for example, I pass away and my wife has already predeceased me, right? I have a child that's 19 years old, right? Do I want that 19-year-old to get a big old inheritance from me? Absolutely not, right? I don't trust kids that are only 19 years old, right? I don't trust kids that are that young. You know why? Because I wouldn't have trusted myself. You would have given me all that money when I was 19, what would I do? Right to the Corvette dealership to buy me a new Corvette, right? Smart? I wouldn't say so, not for a 19-year-old, right? So what we do is we'll set up testamentary trusts, contingent trusts for minor beneficiaries. And when I say minor, I don't mean 18. I don't even necessarily mean 21. You can set that age. Again, you're in control, right? My grandkids, they're a little not so great, right? So I want them to have this money in trust if God forbid they're inheriting, right? Until they're 25, until they're 30, maybe for their whole life, right? And we can set it up so that they get the income. They can still get the money out of the trust for health, education, maintenance, and support, right? They need tuition for Harvard, no problem. We can get it out of the trust. They want to get LASIK eye surgery because their health coverage doesn't cover that type of elective surgery, no problem. We can get it out of the trust, right? But they want $5,000 because they're feeling hot. They want to go to Vegas. Nope, sorry, not out of this trust, right? So that's how, certain things that we can do to help protect our beneficiaries from themselves or from others who want to prey on them. Imagine I was 21 and I got this inheritance. Well, I can drink, I can vote, I can fight in a war, right? I'm still not that mature, right? My friends say, hey, Matt, you just got all that money. Well, let's go spend it. Peer pressure, hey, it sounds good, right? So again, having a testamentary trust for minors that you set, very important to have in your will. Last thing about the will is we can also set up contingent trusts for disabled beneficiaries, right? I'm talking about anybody that's taking under our will. My wife, my kids, my grandkids. I give a little bequest to my brother and he's disabled, God forbid, no problem, right? We have what's called a contingent supplemental needs trust, right? Supplemental needs trusts are so important because most people who are disabled, right, they're on government benefits. Many government benefits are resource-based, right? If they get this big old inheritance, what's the government benefit going to say? They're going to say, nope, you're not eligible anymore. Medicaid being number one, we'll talk about that in a little bit more detail, right? So by giving them their inheritance in a supplemental needs trust, what that means is that they can still keep those government benefits, yet they get that inheritance, and that can take care of anything that they need over and above what the government benefits already provide, right? So Matt, I need a will. Right? I have a lot of these issues in my life. I have a disabled grandchild, right? I'm young and I have minor children. I have some kids that, aren't so great with money, and maybe I want to set up a trust with them in my will so that they're taken care of for, maybe for the rest of their life. We can do that, right? All it takes is sitting down with an estate planning attorney such as myself, discussing your personal situation and figuring out what plan works best for you. There's no cookie cutter here, right? We tailor your estate plan to your particular needs, right? So again, some people need a trust. Some people don't need a trust. I don't say, no, everyone gets a trust, right? So I make more money. Nope, that's not how it works. If you don't need a trust, then we're not going to do a trust for you. If you don't need all these, if you have a very simple situation, you're going to get a very simple will, right? Because that's tailored to your particular needs, all right? So that is the will in a nutshell. Now, wills are required to go through probate, right? So if I pass away and there's any assets in my name alone, that's very important. There you go. The only thing that goes through probate are assets that are in my name alone, right? I have a bank account with my wife, right? When I pass away, does that go through probate? Nope. Because my wife is a surviving joint owner, she automatically gets the money in that account. Done, right? Same thing with the house. I have a life insurance policy. It names my wife. Does that have to go through probate? Do we need an executor to collect on the insurance policy? The answer is no, right? The named beneficiary fills out the paperwork. Life is good, right? Done. Okay. Question? Perfect, perfect question. The question there was, what if you have investment type of assets, CDs, brokerage accounts, things of that nature, right? Maybe a mutual bond or something like that. Again, those all have transfer on death beneficiaries, named beneficiaries, just like you said, those don't go through probate. Okay. And of course, anything that's transferred into the name of a trust is not in your name alone. Therefore, right, the assets of the trust do not go through probate. So what you're telling me, Matt, right, I've kind of put this all together. If all my assets have a joint owner, have a named beneficiary, or are otherwise in a trust, then I've just avoided probate, right? And that's a good thing, and you'll see why during segment number 2, okay? So that's the will right there, all right? Next document, of course, is the power of attorney. So important, right? A power of attorney is a written document where you give somebody else the power, right, to make financial decisions and transactions for you, but only if you can't do it yourself. Remember, as long as you have the right mental capacity, right, your sound mind and body to manage your own financial affairs, the buck stops with you. Nobody can take that away from you. But if God forbid you lose that, you're struck by lightning, right? Of course, there's other situations, Alzheimer's, dementia, so on and so forth, right? God forbid that happens. We need to have that power of attorney in place to make sure that your bills get paid, right? To make sure that we can transfer money around to get you eligible for Medicaid, right? Medicaid's a government program that will pay for your long-term care. What do I mean by long-term care? I mean care either at the house, right? Home health care aides come to help take care of you if God forbid you or a loved one needs that. Or, right, the very last resort, care in an institution, care in a nursing home. And I know what everyone's thinking right now, because all my clients say, Matt, I'm never going to a nursing home, right? And we should all have that goal, right? Joseph's absolutely right. Sometimes, right, we need round the clock skilled nursing care, right? We get to a point where that's our only option. And the only place where we can get that type of care is in a nursing home, right? So again, the goal is to avoid it at all costs, right? But it's available to us if necessary. And if we have our estate plan set up correctly, we can have the government pay for it. Not a dollar comes out of our pocket, right? Now, why is that important? Because long-term care is so expensive. Aides come to the house to help take care of you on a 24-hour basis, or a loved one, right? You're talking about $6,000 to $8,000 a month, okay? Not even a year, 10 months, you're talking about $60,000 to $80,000 out of your pocket. You have that laying around? Maybe. Do you want to spend it? No. That's for my kids. That's for my grandkids. That's for me, right? So again, that's when we'd utilize the Medicaid program to help pay for those long-term care costs. What about a nursing home, Matt? You're talking about $15,000 to $20,000 a month. Not even a year, 10 months. Like easy math. $150,000 to $200,000. You got that laid around? I know I don't. Question. So the question is does that include an assisted living facility? And the answer is no. An assisted living facility actually doesn't really provide you with any care. Therefore, Medicaid won't pay for it, right? But they can be a little bit more hospitable, right? And for some people who say, you know what, I'd rather spend the coin to live in some place where I'm a little bit more comfortable, rather than going into an institution like a nursing home or having aides come home. They're also great for a community, right? Even when you're at home, there's not a lot of people around. Maybe you can't get out of the house as much. But in an assisted living facility, there's other seniors around, right? Other people to hang out with. They have activities, they do field trips. It's actually really great. So that, go ahead. Yep. Yeah, absolutely. Well, that wouldn't be quite as expensive with me. All right. Exactly. And depending what type of planning that we do for you, right? That's correct, right? Assets do have to be out of your name to be eligible for Medicaid, which is why we do this planning in advance, right? We want to get those assets out of your name, right? This way, you achieve the eligibility threshold as far as resources are concerned. We'll talk about that in much more detail during the asset protection segment. Go ahead. Mhm. Well, Medicaid, they will pay for aides to come to the assisted living to help take care of you if you need that. Medicaid, you have to have that and you have to be eligible for it. That's correct. That's why you come see an attorney like me to discuss how we can get you eligible. So Medicare is different. Right. Well, right. Medicare will pay for 100 days in a nursing home. I think it's 26 days in a rehab facility, right? But after that, Medicare doesn't pay for anything. Medicare only pays for your medical expenses, 80% of your medical expenses, right? Then you have a supplemental health insurance policy that fills in the other 20%, all right? Go ahead. Oh, God bless her. Mm-hmm. There you go. Yeah, again, there are. Mhm. Yeah. So there you go. Exactly. Was that here in New York? There you go. That's the difference. That's the difference. See, there are certain assisted livings that do accept Medicaid. They're very limited, and finding rooms in those are it's very few and far between. Yep, that's correct. There you go. So there you go. Exactly. Right. But again, that's why we do this planning in advance so that we could set the plan up so that exactly what we want to happen, we can achieve in the future. All right. Now, but moving on, because we're pressed for time here, right? The next document is a healthcare proxy, right? Healthcare proxy, you probably have a pretty good idea of how that works. It's very similar to the power of attorney, right? The power of attorney, again, where you appoint somebody to do financial transactions and decisions for you if you can't do it yourself. With a healthcare proxy, you're appointing someone to make medical decisions on your behalf, again, if you can't do it yourself. Very, very important. We can also include organ donation provisions in the healthcare proxy. So if that's something that's very important to you, right, you can have that included in your healthcare proxy, right? A lot of people are very uncomfortable with organ donation, anatomical gifts, right? I would say 70% of my clients don't include it. So if you're not comfortable with that, don't feel bad, right? A lot of people, share your same feelings essentially. That's true, but people think about that a lot, right? They say, okay, they're not going to want my organs. I had a client, right, received a letter from somebody, right? Her mother was an organ donor, right? You know what the letter said? The letter said, thank you, right? I got an ACL tendon, right, from your mother. I can now play tennis again. I can chase after my grandkids, right? It really helped that person, right? So again, it can be really beneficial. It can also make you feel a little bit squeamish, right? So again, it's a very personal thing. So again, if you're not comfortable with it, please don't feel bad. Right? That's correct. That one's not quite as strong, right, on the license, just because it just says, yeah, I'm an organ donor, but there's no instructions there really, right? But the healthcare proxy provides those types of instructions. So that's why it's really, meaningful to you, very important to have that document in place and have the organ donation provision included there. The last document, the basic estate plan, is what we call a living will. All right. A living will is what I call the end of life document. Right. What a living will does is it provides instructions as far as how you want your end of life decision making to be undertaken. Right. So if you're suffering from an incurable or irreversible mental or physical condition where there's no reasonable expectation of recovery, not one, but at least 2 doctors have given the same diagnosis. I'm sorry, Mr. Ferdon, there's nothing more that we can do to make you better. You're on the machines, right, for the rest of your life. There's nothing that we can do, unfortunately, right? And I'm in a coma, right? So I can't tell the doctor, right, take me off the machines, but give me, pain medication so I can go with God comfortably, essentially, right? So what the living will does is it provides those instructions to your healthcare proxy. This way, there's no dispute as to what you want, right? No dispute as to how you want your end of life care to be undertaken, right? Now, some people say, right, you can't do that, healthcare proxy. That's not what Matt would have wanted. What's healthcare proxy going to do? Well, look, when Matt was of sound mind and body, he signed a living will that said, this is exactly what I'm supposed to do. I don't want to do it either. But unfortunately, these are Matt's wishes, and this is what we have to do. That's correct. What Joseph said was, you can't change what's written down, right? And that's a good thing, because that means that your wishes are the wishes that are carried out. All right. So that is the basic estate plan in a nutshell, right? Again, everyone should have one in place, I would say, in this room at least, right? I have those documents in place for myself and my wife. I've done it for my parents, my in-laws, right? For my siblings and my in-law siblings. And I've done it for hundreds of seniors as well, right? And young people alike, I should say, right? So again, that is basic estate planning. If we have any further questions, we can do that in the question and answer segment at the end of the seminar. That's correct. So the question was, when we have a married situation, we don't do joint documents. Each person gets their own will, their own power of attorney, their own healthcare proxy, their own living will. Not only that, when you come to an attorney like me, not every attorney does this, I prepare for you 2 originals of the advanced directives of the power of attorney, of the healthcare proxy, of the living will. There's only one last will and testament, right? We're only allowed to have one. This way there's no discrepancies. But we do 2 originals of the advanced planning documents of the advanced directives, because what if we're using one and whoops, right? The dog ate it, right? Or I spilled coffee all over it, right? Sometimes we need to use the power of attorney to sign a deed, right? Maybe we're going to sign the deed over to a trust, or we're going to sell it, right? Because that's part of the estate planning that we're doing in contemplation of Medicaid, whatever, right? If that's the case, we need to record the power of attorney along with the deed. I'm not sure if you guys have ever dealt with the county clerk's office, whether here in Suffolk or in Nassau or even in the city, right? It can take some time, right? So having that second power of attorney doesn't handcuff us. In fact, it helps us do what we need to do if, God forbid, there's an emergency where we need to use the power of attorney. They are exactly identical, exactly, right? So again, it's 2 identical copies of each document, right? Some people say, Matt, you hold on to a set. This way, if I lose it, I know it's safe in your fireproof vault, essentially, right? But a lot of times I just give both documents to my clients. Sometimes they'll hold one, sometimes they'll give one to their children. Right? I always say, keep it in a fireproof lockbox, right? It doesn't have to be in a safe. I always advise against the safe deposit box. Safe deposit box, even if it's jointly owned, requires a court order in order to open it to get to those documents, right? So if we're trying to avoid court, trying to avoid probate with our estate plan, right? And we put these documents into a safe deposit box, well, now we're back in court, right? When the goal was to try to avoid that very thing. Even if the question was, even if the safe deposit box is jointly owned, the answer is yes, right? The reason being is because, right, they don't want the survivor to essentially raid what's in there and change what's going on. Of course, that usually would never happen because, it's people that you love who would be on there, but that's why that's in there, right? So I say, we don't really need safe deposit boxes anymore, right? We have safes at our house. We have fireproof lock boxes, right? So on and so forth. If you want that for like the diamonds, right? or all those gold bricks that you have, then that makes sense. But putting your estate planning documents in there, doesn't. All right. Then the back, I'll get to you next. But so the question is, right, I signed a will 30 years ago. Gives everything to my spouse. If my spouse isn't around, it goes to my kids. My kids' situation hasn't changed. My financial situation hasn't changed. Then the answer is no. It does not need to be updated, right? Now, there are, however, concepts that we've come up with, right? Again, not every will from 30 years ago is going to have a contingent supplemental needs trust for any disabled beneficiaries, right? It might not have those guardian, or you might not need it at that point, but it might just not have some of the kind of really cutting edge concepts that us estate planning attorneys put into those documents. Exactly, right? So I always say it's a good idea to at least have an estate planning attorney review your documents just to make sure that they are up to date, up to snuff, and they're exactly your wishes. Some people say, yeah, it gives everything to my husband and then it goes to my kids per stirpes. But it turns out it wasn't per stirpes, right? It was to the survivor, right? Now, what does per stirpes mean? Good question, right? Per stirpes is a Latin phrase that means down the bloodline. So what I say is, I give everything to my spouse. God forbid my spouse has predeceased me. I give everything to my kids in equal shares per stirpes. What that means, if God forbid one of my children were to predecease me, again, knock on wood, right? Then their share would go to their kids in equal shares. If you just have it as survivor, well, it's going to all go to the surviving child or children, and the grandkids of that predeceased child will not be able to take. All right. So again, very good idea. If you have older documents in place, come see an estate planning attorney. It's a free consultation. You might get lucky and say, hey, you don't have to do anything. All right. And it's for free, and your cares can go away worry-free, essentially. Go ahead. Good question. So that's a very good question. The question was, right, my husband passed away or my wife passed away. I'm named as the executor, right? Or someone else named me as the executor in their will, and now it's my responsibility to administer the estate. Do I have to go back to the attorney that drafted the will? The answer is no, right? You can go to any attorney that you want. Does it make sense to do that? I would say in many instances, the answer is yes, because they already know the situation. They know about the family dynamics that are at play, and it might make things that much smoother kind of moving forward. Now, sometimes, right, what happens? My will's 30 years old, right? The attorney's down in Florida for the last 15 years retired, right? Or whatever, right? Oh, there you go. Or God forbid his passed away, he's no longer practicing law, whatever the situation might be, right? Hopefully not in prison, right? That's the bad one. But my point is you can go to any attorney that you want, right? But what should you do? Should you go to a bankruptcy attorney? Should you go to a corporate attorney? No. Could they do it? Probably. Will they do it smoothly, efficiently, and at the price that you want? The answer is probably not. All right. So again, always good to see a dedicated estate and probate attorney like myself. It's a growing field, so there are a lot around, right? Matt, what attorney should I pick? Well, you should pick me, right? I'm just kidding. You should pick the attorney, any professional, right? That you're most comfortable with. You've met with them, right? They've made you feel comfortable. They're not charging you out the you know what. They're close to home, right? And that makes sense because sometimes they say, oh, you got to go up here and sign this real quick so we can get this done quickly, right? If they're 50 miles away, not so helpful, right? So again, find an attorney that you trust, find an attorney that you're comfortable with, and that's the best attorney to use. All right. Now let's shift focus now to the probate segment. So probate, right, is a court proceeding whereby we send the will for two things to happen, right? We petition the court, the executor, right? You are nominated as the executor in the will. You hire a great attorney, right? and the attorney then drafts the probate documents, essentially, right? There's a petition. The petition says, hi, I'm the executor court. I have the original will. I'm named as the executor, right? Please issue a letter testamentary that officially appoints me as the executor of the estate so that I can start administering the estate, so that I can collect the assets, pay the debts, distribute the assets, whatever's left after paying those expenses of the administration of the estate, distribute the remainder of those assets to the beneficiaries named in that will. All right. So there's a lot of liability for the executor, a lot of responsibility, right? And whenever you have responsibility, that begets liability, right? Whenever you're in charge of money and doling that money out to people, people scrutinize you, right? You say, are you doing it right? Let me see the expenses, right? All those Home Depot charges where you had to repair the house, right? Were those for your house or for the house that we're selling through the estate, right? They're going to look for those types of things, right? And they might scrutinize it, right? The beneficiary. So the question was, who would scrutinize your actions as executor? Great question. That would be the beneficiaries of the estate, because they're the ones who are ultimately, right, getting the money. So they want to make sure that what you did was completely above board, completely proper, and that you didn't waste any of the money, right? One of the biggest things is, okay, I sold the house, but I sold to my buddy, right? So I sold to him for like 100 grand under fair market value. But no, he's a really good guy. He's got a disabled kid. They really needed it. It's a good thing, right? Nope. What you just did as executors, you breached your fiduciary responsibility to the beneficiaries of the estate. Your responsibility as executors to maximize the assets of the estate, right? Therefore, the beneficiaries get the full benefit of their inheritance, essentially, right? So that's why it's super important to hire an attorney to go through the probate process, right? And it's not cheap. I won't lie to you guys, right? Good question. The question was, and it's such a great question because I get it every single time. The question was, even though I've just drafted this beautiful will that you did for me, Matt, right? And it clearly states all of my wishes and what's supposed to happen after I pass away, why would I possibly have to go through the probate process? The reason being is because what if there was fraud? What if somebody forced you to sign that will, giving everything your favorite estate planning attorney? Don't do that. All right. Your heirs are going to say, whoa, 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 this isn't right. Right. So what the probate process does, it gives the heirs their day in court. Right. It gives them the ability to challenge the will, to say, nope, this isn't right. Or nope, Matt can't be the executor. Matt's a bankrupt. Matt's a felon. None of those things are true. Right. Matt's disqualified from being the executor for some reason or another. Right. And therefore he shouldn't be in charge. So even though, right, the will is right, maybe the executor isn't right. And imagine this, right? Remember that will we signed 30 years ago, where I first appointed, my spouse as the executor. Then I, appointed my first kid as the backup. Well, my first kid over that 30 years became not such a great kid, right? Drugs, alcohol, gambling, take your pick, right? White collar crime, whatever, right? They're not, qualified for the office of executor at this point, right? So even though they're trying to get themselves appointed as executor, the other heirs are going to jump up and say, no, court, this can't happen. Look, he's got a record longer than Matt's time, essentially, right? So again, great question. That's why we go through the probate process. Question? Yep. Correct. That's correct. It's another great question. The question was, right, we have spouses, right? We have husband and wife or whatever, right? Whatever the situation might be. When the first spouse dies, now generally, do we have to go through probate for the first spouse? The answer is generally no. Why is that? Because everything was jointly owned. I named my spouse as the named beneficiary on my IRA, on my brokerage account, on my life insurance policy. And I put my house in a trust, right? So again, nothing has to happen when the first one dies. Now, right? My wife dies before me, right? So everything came to me. Oh, great, right? But now everything's in my name alone. right? So at that point, we'd have to probate the surviving spouse's will, right? Or even better, go see an attorney like Matt and update our estate plan, right? Maybe get the kids on some of those accounts, right? Get some of those assets in, into the trust, not just the house, so that it's out of my name alone, so on and so forth, right? So a lot of times, what did I say, right? When we want to update our will, if there's a familial change, if there's a change in our family situation. So if your spouse passes away, even if you don't have to go through probate, it's still a really good idea to go see the estate planning attorney to update the surviving spouse's plan so that everything is smooth, efficient, and accomplishes the wishes of the surviving spouse. So the question was, is there a minimum age, right, before you can put a child on something? The answer is yes. First, they generally should be 18, and that's it, really. Now, once we get to the asset protection, which we're going to go to in just a second, we don't necessarily want to transfer things to our kids outright, right? And you'll see there's a lot of risk that comes along with that. So we'll touch on that in just a few minutes, all right? Probate's pretty simple, right? And it's simple because you have an attorney kind of doing all the work for you, right? Guiding you, telling you what needs to happen. And our goal is to avoid probate, right? I just went through all this information about probate. Why do we like to avoid probate? A couple of different reasons. First, and we already went through one, right? We can challenge the plan in probate, right? So let's say, right, we'll pick on me again. I create a will, right? I give everything to my wife. But if my wife predeceases me, I give everything to my daughter because my son was one of those not so great kids, right? Drugs, gambling, alcohol, whatever you want to do, right? If my will goes through probate, we have to get consent of all of my heirs, right? So my two kids, essentially, including the one that I disinherited. What are the chances that we get the consent from the disinherited heir? Oh, sure, no problem. Give everything to my sister. I don't need a dime. Think that's going to happen? Right? Oh, everybody, all at once. No, right? Not going to happen, right? So if we have that type of situation, is it a good idea for all of our estate to go through probate? The answer is no. Probate avoidance is really important in that case. And we do that with a trust, right? We would set up a trust, right, to get our assets into the name of trust. Therefore, they don't have to go through probate. And the beautiful part about that is the trustee, upon your passing, is automatically empowered to transfer the assets to the named beneficiaries that you put in the trust. Go ahead. Hmm? Good question, right? So the question was, right, we have a husband and wife situation and the husband and wife had children, right? The question was what if the husband and wife have grandchildren? Can they throw the monkey wrench into the estate plan? And the answer is no, right? Your grandchildren are not your heirs unless the child in between has predeceased you, right? I'll do just two different examples, right? I pass away, right? I have a wife and two kids. Who are my heirs? My wife and my two kids. Easy, right? I pass away. I have no kids. I have no wife. Who are my heirs? Uh-oh. Well, now we got to figure it out. Starts with parents, no parents, siblings, exactly. No, what's that? See, this is different though, right? We name beneficiaries in our will. We don't name heirs. Heirs are people who would inherit under our estate if there is no will, right? So for example, right, again, I have no wife, I have no kids, right? I decide I'm going to give everything to charity. I can do that, right? No problem. However, my heirs can then challenge that if they want and say, no, Matt was crazy. He didn't want to give everything to St. Jude's Children's Hospital. He wanted to give everything to me, right? So there would be a fight at that point, right? So again, that's what we would basically do. Now, again, right, when we want to disinherit somebody, one of those heirs, then that's when they can throw a monkey wrench. That's when we want to avoid probate, essentially. Sure. Mm-hmm. Yep. Mm-hmm. The answer is no. That's a common misconception, right? People often say, oh, I'll leave this person $1. I'll leave them 100. I'll leave them 500. I'll leave them 1,000, and that'll shut them up. The answer is no. They still have to get that person's consent. If that person feels that this will was done fraudulently, right, or the person didn't have the testamentary capacity to sign the will at the time, then they have the ability to challenge it. The worst part about that is it could be all right, meaning even though I have slipping a little bit capacity-wise, right, I still wanted to disinherit this person. Those are my wishes, whether I had testamentary capacity or not, right? So that's why avoiding probate is so important, because we can keep that plan intact a little bit, much easier. You could. So if there's a an interim clause, a no contest clause, and it says, okay, I give 25% to one kid and 75% to another. If they challenge it and they lose, they get 0, right? So there are layers of protection that we build into the will, but they don't work as well as we'd really like them to, which is why the trust is so important. Question? It's hard to put a number on it. It really depends on the situation. Most wills that go through probate go through pretty easily, right? Because it's just the wife, there's just kids. Exactly, right? And the consent is easy because no one's being disinherited, right? It's a paper proceeding at that point. We just fill out the correct paperwork. The court issues the documentation that they have to do. The executor does what he or she has to do. Life is good. Question? It depends. So stepchildren is a very vague term, right? Some people don't even get married, right? And they consider their partner's kids to be their stepkids. They're not, right? Some people get married, but the kids are already 35 or 36 or whatever, right? Even though they're stepchildren, they're not adopted stepchildren. The only way stepchildren can rear their ugly heads, if they have ugly heads, right? Or if they're actually adopted by the person who's passed away. And again, that usually only happens when the kids are very young, right? And a lot of times that doesn't happen because their spouse is still around and there's no need for an adoption, right? So again, stepchildren, right, often don't have the ability to throw the monkey wrench into the estate plan, but who does? Half siblings, right? Their family, their blood, their heirs, right? They come up out of the woodwork and say, hey, nope, gotta include me. They challenge the will and they win, right? That's why avoiding probate can be so important in certain situations, right? Yep, doesn't matter. Doesn't matter. That's correct. No matter what. No matter what. Perfect. There you go. Mm-hmm. Easy. That would be subjected to probate. Exactly. That's it. Exactly. So the question was, even if I have the simplest situation in the world, do I still have to go through probate? The answer is yes. It's just part of the process, because the court would rather, right? It's the same thing with criminal court. We'd rather 10 guilty men go free than one innocent man go to jail, right? Or woman, right? It's the same thing. We'd rather 10 contests where they lose than one where there is no contest and someone gets, screwed, for lack of a better word. When you go through probate, it's a court proceeding. The question was, do you have to go through court? The answer is yes. It takes a long time and it's expensive. You got to pay an attorney like me, right? I'll usually take a $2,500 retainer. It's one of the only things I bill hourly for. So that if there's a lot of snafus or people aren't getting along, that the fees can get pretty high. Court fees are very high. And that was the gentleman's question before, but that's because they didn't see an attorney like me. Right. Exactly. But that's why they see an attorney like me. Matt, what do I got to do? Do I have to go through probate? Yes. Then how do I avoid it? This is how we do it. Question in the back? Not necessarily everything, right? Again, right? But what are the three categories? Jointly owned assets, they don't go through probate. Assets with a named beneficiary, and of course, assets in a trust. A lot of times when someone passes away, they'll have all three categories. They have a joint bank account with their spouse or with one of their kids, just so that it avoids probate, right? That's where the Social Security comes, or the pension or whatever, right? They'll have a life insurance policy that has a named beneficiary, or an IRA with a named beneficiary, or a brokerage account with a named beneficiary. And then their house and other non-qualified assets, right? Investments will go into the trust, right? So that's why you come to see somebody like me, so I can look at your financial snapshot. This is what we need to do with that one. This is what we need to do with this one, and we're good to go. Last question, then we'll go to asset protection. So the question was, when we set up a life estate with a piece of real property, with a house, does that also avoid probate? The answer is yes. So first of all, what's a life estate? Great question, right? A life estate is where I transfer my property to somebody else, but I reserve the ability to live there until I pass away. So we used to use life estates a lot, right? Because we didn't use trusts quite as much, right? But you'll see in just a second why a life estate isn't necessarily the best idea, right? And I think that's a perfect segue, right? A perfect segue into the last segment that we'll be discussing. That's asset protection, right? So important. For the younger people in our group here, not quite as important, right? Unless you got a lot of money, right? Or perhaps you are engaged in some type of business where your liability is real high. Doctors, right? They kind of check off both boxes. Yes, they're doing pretty well for themselves, and they're in a high liability type of business, right? Where they might get sued a lot, right? So even though they have malpractice insurance, I'm going to be extra safe and get these assets into an asset protection trust so my creditors can't go after them, all right? So what do I mean by asset protection, right? I mean, right, getting assets out of your name into an irrevocable, income-only asset protection trust. Very, very important. First of all, what's a trust? Always a common question that I get. And people say, Matt, trusts are so complicated. They're not, right? What's a trust? Trust is just a legal agreement. That's it. Done. Legal agreement between who? Two parties. The grantor, the person that's creating the trust, and the trustees or trustee, the person or persons who are managing the assets of the trust, right? So I want to create a trust. What do? Well, first I go see the attorney, right? But really, what am I doing? Boiled down to its most basic form. I'm saying, hey, trustee, right? I'm going to put these assets into a trust that you're going to be in charge of. I want you to manage those assets according to the terms of the trust. You don't just do whatever you want with those assets. You got to follow what I say in the trust, right? You do that while I'm alive. When I pass away, or both me and my spouse have passed away, then I want you to distribute those assets to the remainder beneficiaries that I've named in that trust. It's that easy, right? If we do it that way, we can get a lot of benefits. First, we get the benefit that we've already discussed, avoiding probate, right? And then if we set up the trust a certain way, we can get other benefits as well. Eligibility for Medicaid, protection from creditors, estate tax mitigation. Those are for the really rich people, right? Question? Okay, so good question here. The question is, right, Matt, I set up this beautiful new asset protection trust, right? How could I qualify for Medicaid? Well, first of all, let's talk about the qualifications for Medicaid. What do we need to do to be eligible for Medicaid? Again, 3 boxes that we have to check off. First, what we have to do, we have to have a chronic illness. Well, you wouldn't be talking to me about Medicaid if we didn't have a chronic illness, right? Chronic illness just means you have issues with activities of daily living. What are activities of daily living? Walking around, bathing, using the toilet, cooking your meals, right? If we have enough issues with that, well, then we have a chronic illness. Now we want someone to pay for our long-term care, and we've checked off the first box. Box 2 is resources, right? The individual can only have roughly $16,000 in assets in their name. If they met, I blow right through that. I have a house that's worth 500 grand, right? I have an IRA that's worth 250. I have an insurance policy that's 500. I'm now at 1.25 million. How am I possibly going to be eligible for Medicaid? Right? Well, I'll say, okay, you're not eligible for Medicaid right now, but if you do the planning in an advanced manner, if the timing is right, we can get those assets out of your name using an asset protection trust or other means, which we'll discuss, right? And then at that point, you'll be under that $16,000 threshold. You still benefit from those assets. It's not like you're giving those assets away and you don't touch them, you don't benefit from them anymore. No, they're still yours. You still get the benefit from them. You still get the income that they create. You still get the exclusive right to live in the house that we've transferred into the trust. Nothing really changes except the paper. Who owns those assets? That's it, right? Now, the third criteria is income. You said, Matt, right? I make all this income, right? Not a huge deal. Now, first of all, if you make too much income that each month you can just pay for it yourself, you're not going to be eligible for Medicaid. But then that's okay because you make 6 to 8 grand a month. It's a lot of money, right? So again, Medicaid not so necessary there, right? But let's say you can only make about $900 each month to be eligible for community Medicaid, that is for the aides to come to the house to help take care of you, right? So what if you make $1,900 a month? So you're exactly $1,000 over. No problem, right? We have a mechanism called a pooled supplemental needs trust. Pooled supplemental needs trust, PSNT, right? Very important. What we do is we take the overage, it was exactly $1,000 over each month, right? We sign up for the pooled supplemental needs trust, the PSNT, and we send that $1,000, that overage. The $900 that's left over, that's yours. You can do it whatever you want, or the Medicaid recipient, if it's mom or dad or whoever, right? So that doesn't change. You can still buy whatever you want with that $900. But that $1,000, that overage, we send that to the pooled supplemental needs trust. But then what do? We send them bills in the Medicaid recipient's name, right? The cable bill, the utility bills. How about a credit card in their name where we buy food and clothing each month or whatever, right? No problem, right? We can send bills up to the $1,000 and then the trustee of the pooled supplemental needs trust then pays those bills with that $1,000 overage. We're sending it to the trustee, the PSNT, the person in charge of managing the pooled supplemental needs trust. So we've gotten our expenses paid and we've done it in such a way that we're now eligible for Medicaid, even though we make too much money. Go ahead. Again, the limit there is if the cost of your care is, let's say, $7,000 a month and you make $7,000 a month or over, you're never going to be eligible for Medicaid. Okay, so that's important. That's important. All right. So that's why you come to see me or an estate planning attorney like myself, right? We examine the financial snapshot of the Medicaid recipient or the potential Medicaid recipient, right? And then we figure out, okay, this is what we can do. We need to work within their rules, but we have a little bit of wiggle room. And that's essentially what we would do. I personally have gotten someone with $3 million in assets eligible for Medicaid and accepted on Medicaid. All right. So again, that's a lot of money, but it's not a lot of money on Long Island, right? You know, it's a lot of money in Nebraska. It's a lot of money in Tennessee. But here on Long Island, I mean, we need all that money to survive, as you know, with gas and property taxes, recording fees, right? We want to transfer the house into the trust. So we sign a deed that goes from the grantor to the trustees of the trust. Done, right? I'll charge you $500 to do that. You know how much it'll cost to record that deed in just Suffolk County? $670, right? So the greedy attorney, right, doesn't even charge as much as the county clerk to record that deed, right? Again, what's that? No, you still got to pay that. Still got to pay that. My point is in Georgia, it's $30, right? In Florida, it's 25, right? And a lot of places, it's a lot cheaper. Everything is more expensive here on Long Island, right? But we'll also have a really great Medicaid program. Tennessee doesn't have such a great Medicaid program. Texas, good luck, right? Of course, Florida has a really great Medicaid program. So if you're thinking about that, but Florida has its own set of pitfalls, so on and so, right? Good. Sure. Mhm. Yep. The answer is yes, right? Because again, as long as you had it titled correctly, right, it all goes to the surviving spouse essentially, right? So nothing changes, right? Nothing changes, and in fact, it might even get even better because I have a $2 million insurance policy on myself. When I die, my wife gets $2 million, right? So not only does she get all the assets that we've accrued during my lifetime, she gets an extra $2 million too. Not so big, right? So again, but that's only going to work if we plan for it. That's why you come to an estate planning like myself. Mhm. Thank you. Mhm. There you go. Now, okay, first of all, your documents don't just die with me. Your documents are still good, even though your estate planning attorney isn't around anymore. Unfortunately, at that point, you're going to have to find a new estate planning attorney. But like I said, you can practically swing a dead cat and hit an estate planning attorney nowadays. Yep. Correct. Now, there you go. And he might look at those, and he probably will look at those, he or she, right? We have a lot of great estate planning attorneys, both male and female, right? But what's going to happen there? They're going to look at those documents and say, what are your goals? Have they changed? Do we need to update these documents? Do we have that contingent trust for minors in there? Do we have that contingent trust for disabled beneficiaries in there? Well, let's get that in there because that's really important. If they were my documents, they're going to have all that stuff in there, right? But not everyone does. Go ahead, question. That's correct. Oh, guys, such a smart group here, right? Great question, right? So yeah, the question was, we're setting up an irrevocable asset protection trust. Who is going to be the trustee, right? The answer is whoever the grantor wants, except for the grantor themselves. So rule number one for an irrevocable asset protection trust, right, that we set up usually for Medicaid purposes, right, is the grantor cannot be the trustee. So usually, who would the grantor appoint? Their children. Can't appoint the spouse, right? Because we want to go back and forth, and the spouse is also a beneficiary of the trust, right? So a lot of times when I have a married couple, right, it'll be the Ferdon family irrevocable trust, as opposed to the Matthew V. Ferdon irrevocable trust, right? So it can't be the spouse, but again, usually it's the kids. Matt, what if my kids are rotten? Who do I appoint? Oh, brother, a sister, a niece, a nephew, a friend who's an accountant or a lawyer, or just really good with finances, so on and so forth. Again, the question was, what if you're a single person not married, right? Don't have any kids? Well, you got to figure out who, is appropriate to appoint as your trustee. Maybe it's a sibling. Matt, I hate my sister, and I don't want it to be my sister, right? So who would it be? Again, a friend, a niece, a nephew, someone close to you who you trust, essentially, right? So that's rule number one, grantor can't be the trustee. Now, this is really important. I hope you guys have your pens ready, right? The only other rule that we have to follow as far as the trust is concerned is what we call the no principal rule. No principal rule, right? We put assets into a trust. Those assets are considered to be principal, right? If that principal are income-bearing assets, stock, other investments, maybe it's a property that we rent out, whatever, then the income goes back to the grantor. The grantor then reports that income on their 1040, on their tax return, either their joint tax return or their individual tax return. It's no matter. Do they pay the very high trust tax rate? The answer is no, right? They pay whatever tax bracket that they're in. That's the tax rate that they'll pay. So remember I said nothing really changes? You were getting that income before and reporting it on your 1040. Now it's going to go into the trust. You're still getting that income. You're still going to report it in the exact same manner. Nothing changes, even though you put these assets into an irrevocable asset protection trust as far as income taxes are concerned. So first of all, what'd you say first? The question was, what about my 401k? 401ks are tax qualified retirement assets. 401ks, 403bs, IRAs, deferred compensation accounts, so on and so forth. Annuities, that are retirement based that you get through employment. Okay, not most annuities aren't. Most annuities are purchased privately and so on and so forth. That's not tax qualified, right? But tax qualified retirement assets are already protected from the reach of Medicaid, right? Now, so we'd never put those types of assets into an irrevocable trust. And you say, Matt, protected from Medicaid, what do you mean by that? Now, Medicaid's a little sneaky, right? They say, you gotta check off those 3 boxes. Well, I saw an attorney, I check off those 3 boxes, or maybe I already check off those 3 boxes. I didn't have to see an attorney, right? But one of your assets is your primary residence. And Medicaid says, don't worry, we don't count your primary residence for eligibility purposes, right? So we'll pick on me again, right? I have a house, right? It's my primary residence. It's worth 500 grand. I'm just making numbers up here, right? And I really have nothing else. I'm really already eligible for Medicaid, right? But I didn't put my house into an irrevocable asset protection trust. I go on to Medicaid. They take care of me for 4, 5, 6 years. I rack up a $500,000 bill. What they're going to do at that point, what they didn't tell me was, Matt, we're going to put a lien on your house, right? For that 500 grand, right? Well, no, that was my legacy for my kids. I worked my whole life for this, right? This is why I saved and I worked, right? And I didn't buy that Corvette, right? For my legacy for my kids. And now you're saying you're going to take that all away with the Medicaid lien? Well, if you just came to see me, we'd put that primary residence into an irrevocable asset protection trust, right? And now they're not able to put that lien on that house. Good. Revocable trust. The question was, is that the best trust to use for asset protection purposes? Absolutely, right? The question was, what about a revocable trust, which we really didn't discuss tonight. That'll be for another night, right? A revocable trust is a trust where the grantor is the trustee or can be the trustee, right? The assets can go back to the trustee, to the grantor at any time, right? Therefore, there's no asset protection. They still have full dominion and control over those assets. So there's no asset protection. All right. Back to the no principal rule. Very, very important, right? Go ahead, question. That's a great question. I love this group. The answer is yes, right? The house can still be sold through the irrevocable asset protection trust. What's the difference? I'm the grantor. Am I selling the house? Nope. My trustee is. My trustee signs the contract. My trustee does all the title stuff. My trustee goes to the closing to sign all the documents. Nope. The money goes to the trust. The money goes into the trust. Then maybe we want to downsize. We sold the house. We want to buy a over 55 condo. Can we use the money from the trust to buy it? Yep. Doesn't go back to me. It's all done through the trust by my trustees, essentially. So again, that no principal rule means any principal that we put into the trust can't go back to the grantor directly. But what do? Do we build in a back door for that? Of course we do. We're smart attorneys, right? We took these concepts for really rich people and we're now applying them to the middle class, essentially, so that we can achieve asset protection and Medicaid eligibility, so on and so forth. Go ahead. It can be. It often is. It makes sense. I like continuity. That's a smart plan to me, right? I would say the power of attorney, the executor, and the trustee should usually be the same person because it's very similar types of offices. Can it be more than one person? Yep. I can name both my kids. No problem. Maybe my kid's a little young. I'm a little worried. So I appoint both my kid and my brother because he's a little bit older and so on and so forth. You can have more than one executor, yes. All right. We don't love it because it can create problems, but if those are your wishes, that's something that we can do. Now, back to the no principal rule. Again, very important. Principal that we put into the trust can't go back to the grantor, but we build in that back door. What's the back door, Matt? Good question, right? The back door is a provision that we put in there, right, where we can appoint principal beneficiaries. Can't be the grantor or the spouse, right? But who do we usually appoint as the principal beneficiary of the trust? I'll give you one guess. Exactly the kids. Perfect. You got it, Joseph, right? So perfect, right? So again, right, we've sold that house, right? Remember we sold the house and we're buying that over 55? We sold the house for 600. We're buying the over 55 for 300, right? But we need new floors and a kitchen. I can't live in this place like this, right? So what do? There's 300,000 extra dollars just sitting in the trust, right? What the trustee would do is distribute that, some of that money, $50,000 for the new, the remodeling, not to the grantor, but to one of the principal beneficiaries. Then principal beneficiary gives that money to the grantor or pays for whatever needs to be paid for, so on and so forth, right? Usually, good idea is a phone call to your attorney who set up the trust. Hey, Matt, this is what we're thinking about doing. Does this work? Absolutely. You just got to do it, in this order, essentially. That's it. Well, it depends. So the question was, right, first of all income is considered for Medicaid purposes. Income for your 401k, income from the trust, income from every other source. The question was, if you have all this income, you're not going to be eligible for Medicaid. The answer is yes, right? But here's the thing. If you come to me and you say, Matt, I make $8,000 a year, I make $8,000 a month, right? Or 10 grand a month or 15 grand a month, right? I'm going to say, you don't need this type of asset protection trust. You don't need a Medicaid asset protection trust. I'm not going to sell you something that you don't need, right? Now I'm going to worry about estate taxes. Chances are, how do you make all that income? You probably have a good amount of assets that need to be protected from estate tax, essentially. So now the conversation shifts, right? So again, we tailor the estate plan to your particular needs, right? Go ahead, question about it. Yep. Okay, so two different concepts here, right? So the question was, there's a 5-year look back period for institutional Medicaid, for applying to Medicaid for a nursing home, essentially, right? There's now a 30-month look back period, right? 2.5-year look back period when applying for community Medicaid. So there's now a look back period for both, all right? The question is, what can you give away in those 5 years or 2.5 years? The answer is really nothing, right? You're not allowed to do that, right? So that's why setting up the plan in advance is so important, right? You hit age 68, 70, 72, you come to see me and we shift things around as needed. Now, what if we have a spouse involved? Spouses can transfer money to each other without penalty. So when there's a spouse involved, it's a really great Medicaid situation, right? We always protect the house. Maybe we protect some other, liquid assets, investments, so on and so forth. But we can leave money outside of the trust because if, God forbid, one of the spouses gets sick and needs long-term care, we just transfer everything else to the well spouse, and now that spouse is good to go. See a little bit of problem there, though? What if well spouse gets sick down the road? Well, that's when we do some post-Medicaid, right, acceptance planning to try to mitigate that as much as possible. In the end, it's a plan. Can the plan go awry? The answer is yes. But there's usually a contingency that we can do to fix it, essentially. It's more painful if we have to do it that way, meaning, right, if there's transfers within the 5 years, we have to deal with that, right? If we do it so that there are no transfers within the next 5 years, right, or we transfer among spouses, very easy to deal with. Medicaid's actually pretty simple process about that. Question? Well, it depends on the trust, right? So again, some people say, right, I heard someone ask about out-of-state real property, right? So I'm a young guy, I have a house, right? I decide, you know what, I'm gonna buy that beach house in Florida. I'm gonna buy a hunting cottage in Pennsylvania. Now I have out-of-state real property, right? Even though I'm young, I might want to set up a revocable trust that I'm still in charge of, that I can still get the principal back at any point, but there's no asset protection. This way I can avoid probate for the out-of-state real property. Why is that important? Because with out-of-state real property, you have to go through probate twice, right? Here in New York where you passed away, then again in Pennsylvania where the country house was, then again in Florida, right, where the beach house was, so on and so forth. So again, the question was, right, how old do I have to be to set up a trust? It depends what type of trust, right? An irrevocable asset protection trust for Medicaid purposes, if you're 50 years old, I don't suggest that, right? It's not, you still got a lot going on. But when you're 65, you're contemplating retirement, right? Maybe some health issues have crept up a little bit, right? That's when I say it's go time, right? Let's really delve into your financial situation, figure out exactly what needs to go into the trust, right? And go from there. Even if you just put your primary residence in there, again, on Long Island, you're talking about protecting $400,000, $500,000, $600,000 worth of asset, right? And nothing changes when we put that house into the trust. Mm-hmm. Now, they're going to try to go after all of your assets, depending on how much your Medicaid bill is, right? I had a woman who had a $900,000 Medicaid claim, right? Medicaid claim. So she was in a nursing home for 11 years, right? Luckily, we protected all of her assets. They didn't get it done, right? I've had other people who come to me to say, Matt, mom passed away. She was in a nursing home. Now we got to deal with this Medicaid lien. What do we do? Really, no choice at that point. Yep. Well, so yeah, you can't really do that, right? Medicaid can only go after assets that are in your name, right? But good question. This is something I really want to touch on. It goes back to that life estate question, right? A lot of people say, you know what, Matt, I don't love the trust, right? I'd rather just give my assets to my kids now. They let me live in the house either through a life estate or whatever, right? And I'm good. And now the assets are out of my name. I'm eligible for Medicaid and they're protected. Do I love that? Really? Why is that? When we do an outright transfer of assets to our kids, there's a lot of risk involved. I call that risk the D's, right? What are the D's? Death, disability, divorce, debt, right? I transferred my house, right? Me and my wife, we transfer it to our two children equally. We have a life estate, great, right? One of them gets divorced. Now my primary residence is subject to that divorce proceeding. Good idea? No. What if, God forbid, knock on wood, one of my kids passes away, right? Or both of them. Well, now they have to go through probate for that, right? So on and so forth. Now it's a headache with my primary residence. What if they go into debt? Oh, I started my own small business. A lot of small businesses fail, right? Got to pay the bank back still. They go after my house, my primary residence, because my kid, right? Their creditors are going after it. The trust eliminates all of that. Go ahead. It depends on the situation, right? That's why we set up a plan, right? We identify your goals. What are your goals? Some people say, Matt, I'm dying in this house. Okay, then we'll set up a plan that allows that to happen a little bit more easily. It can be. That's absolutely true. It's absolutely true. You hear a lot of horror stories. There's no question about it. Yet I also hear a lot of really great stories where they become part of the family. So again, you got to look at it from both sides of the coin there. Some people say, you know what, I want that community. Let's sell the house. Let's get that money into an irrevocable asset protection trust. We'll use the income to at least partially pay for the assisted living facility bill each month, right? It's protected, so I can still get Medicaid if I need help there, so on and so forth. So again, it really depends what your goals are. The answer is yes, maybe an assisted living makes a little bit more sense for your particular situation or mom or dad's particular situation. Then we'll consider that, right? It's all what you want, essentially. We're pretty much coming up to the end here, right? The last thing that I really want to hammer home with the irrevocable asset protection trust is nothing changes. The trust specifically says that the grantor, even though you're giving up ownership of the house, the trust specifically says that you have, and you only have, the exclusive right to live in that property from now until the time you pass away. You still pay the property taxes, right? You're still responsible for that. So all of your property tax abatements stay in place, right? You're a veteran, right? that veteran exemption stays in place. You get enhanced star, right? No problem if it's in the trust, you still get the enhanced star. You get a disability deduction, that stays in place too, right? I heard one say capital gains, right? That's if you sell it. Matt, I don't want to transfer the house into the trust because I'm going to lose my $250,000 individual capital gains tax exemption. Me and my wife, we get a $500,000 capital gains tax exemption. Do we lose that if we put it into the trust? Absolutely not. I wouldn't suggest it, right? If you did, right? Because it's still your primary residence. You still pay the carrying costs. Therefore, you still get all those benefits. Question? Documents travel. The documents travel, right? So everything stays the same. Your trust stays the same. The will stays the same, right? Healthcare proxy, so on and so forth. The only thing that I would suggest that you look at is the power of attorney, right? So you move to Florida, you move to North Carolina, you move to Pennsylvania, whatever, right? All your documents are good. What I would do is just go see an estate planning attorney in that state and say, look at my New York power of attorney. Does this fly in this state? Is there special language that needs to be in there specific to this state? And they might say, yep, you should really sign one that conforms to our laws, essentially, right? But that's only one document. That's not so bad, right? Now, we're very sophisticated in New York, right? We're at the cutting edge of the legal field in almost every facet, right? So a lot of our documents are really great already. So you don't even have to change them because we're just crazy about it, right? You can get a power of attorney in New Jersey, it's like 3 pages long, right? Some other states is the same way, right? But my power of attorney, it's like 11, 12 pages long. There's a lot of powers in there. There's a lot of caveats, a lot of things that would have to be followed, all right? I'll take a couple of last questions if we have them, and I think we have to make an escape. Go ahead. Another great question, right? Another great question. And I'm not just worried about divorce, right? The question is, how do I protect my beneficiaries? How do I protect my kids from themselves and from their creditors and from their nasty spouses and so on and so forth? The answer is yes, we can do that too, right? We can set up lifetime trusts for them. There you go, exactly. And a couple more bucks, that's it. Come to see me. We can address a lot of these issues, all right? Go ahead. My pleasure. Oh, yeah, I agree.